She walks into court, accused of breaking bond conditions, just minutes late past curfew, but in this courtroom, even minutes matter. A mother of two, juggling a special needs child and a snowstorm panic, now stands face to face with a judge known for zero tolerance. But as her lawyer pleads leniency, you can almost feel the tension rise. Is this a simple mistake or a pattern of defiance hiding behind excuses? And when the judge warns, it won't happen again, we have to ask, is that compassion or the calm before the storm?
There's a few things to address, Your Honor. There is a bond violation currently right now, and we of course want to address that. I believe it occurred on the 19th of January, her being, I think, either 14 or 17 minutes late, I guess the curfew. And so when I spoke with my client on this, she explained it as far as what the situation was. This was the Friday right before the big snow, and everyone was going crazy. Of course, we all anticipated like it was going to be the last freeze. So she went to the store to be able to get supplies and load up on all of the necessaries, as everyone felt they should. And of course, the stores are crowded. Traffic is everywhere. Prior to going to the store, my client took her 3-year-old daughter to her 70-year-old aunt's house. And the reason being is because, one, her daughter is special needs and she just does not do well in a social setting. And recognizing that it was just craziness, she had to take her there first. Lines along, everything, once she leaves the store, it's apparent that, she very well may not be able to make curfew, but she did have to go get her daughter.
So we only have the one violation at 7:15?
That's correct.
Is that it?
That's it.
Okay. Come up, Mr. Treadwell. Ma'am, it's not the end of the world. I get it. But bond conditions are bond conditions, and you have 2 open DWIs, and you must understand that you and I are operating under strict compliance. And we'll give you a pass now. It's not going to happen again, though. Do you understand? Okay. All right, counsel.
Other matter, Your Honor, we did also want to approach on the court's consideration, or more so reconsideration, of the recommendation for inpatient treatment. Now, we visited this previously.
Correct. And every time I deviate from said thing, we end up regretting it.
And
10 times over. So
you shared that with us last time. I do understand that. I at least want to do my client a little justice and at least give him some reasoning behind why we believe outpatient would be a little more appropriate. So the first thing is my client, she has been sober for 103 days.
Now comes the real clash, inpatient versus outpatient treatment. To most people, that sounds like a small detail, but legally, it's everything. Inpatient means 180 days away from home, family, and freedom. Outpatient, she gets to stay home, but the judge has seen this movie before, and it never ends well. Every time he's deviated, he says he's regretted it. You can hear the fatigue in his voice. He's done giving chances. So, the question becomes, will her 103 days of sobriety be enough to convince him, or is the system simply out of mercy?
She has exercised diligently and staying committed to sobriety. While she has been released, she has been regularly attending AA meetings, meeting with substance abuse counselor who just had a home visit with her a few days ago. She has obtained her health insurance, which was previously lost due to the loss in employment. But now she can further recovery by taking advantage of the psychiatric care, therapy, and whatnot. And 2, and this is really primary, the family circumstances. The circumstances of the family are the type that requires my client's presence at home. She is the caregiver primary caregiver of 2 daughters, ages 10 and 3. The 3-year-old, as we shared before, is a special needs child. And when she was in custody after the second offense, it was her parents who did take care of the children.
So luckily we have that going.
Well, yeah.
Have someone to watch the kids,
Yeah, and
Okay.
that was for just about 30 days or so. Definitely operated as a hardship as to the parents. And of course, in these kind of situations, there's going to be sacrifices. Sacrifices has to be made by all parties. But we're talking about now 180 days, 6 times that amount, which, again, I think it would be a tremendous hardship. And particularly with, I think a lot could be said about it, but particularly with the special needs child, what we do know about that demographic is
Her lawyer shifts gears from law to life. He paints a picture of two little girls who need their mother, one of them special needs, craving routine and stability. You can hear the plea between the lines. She's trying, Your Honor. She's rebuilding. But this is the cruel paradox of the justice system. Compassion has limits, especially when public safety is on the other side. So ask yourself, should motherhood be a shield against consequence, or does accountability come first, even if it breaks the family apart?
they need routine. Routine is keen in their lives. If that is removed, it's, they could get discombobulated and it could operate as a crisis to them. So what we do know is if she does have to go to this outpatient program, home is no longer going to be there. They're going to have to move with whomever.
You say she doesn't have health insurance?
Oh, she does. She does now. She obtained it as of July 31st. July 31st, right? Yes. I'm sorry, January 31st, excuse me. But yeah, so they would have to move. They would have to switch schools, just uprooted from the life that these girls do know and understand. And again, particularly with the special needs one, possibly not even be able to attend. Is it occupational therapy? Occupational and speech therapy. Thirdly, Your Honor, when early on in this case, I had acknowledged, I had informed the court of my client, she is prescribed Adderall. And at the time of the offense, during the time of these offenses, her therapist had, they were adjusting her meds, even had her on an extremely high dose of Adderall. And, I don't want to portray myself as an expert in this at all, because I just found this information out. And that is that Adderall with alcohol, of course, that's a bad idea already. Okay, but what it does on a molecular level, they're both fighting for enzymes, and the enzymes are what's extracting it, getting it out of the body.
And then the twist no one saw coming. The lawyer reveals that his client was prescribed Adderall during the time of her DUIs and that the medication masked her alcohol levels, making her dangerously unaware of how intoxicated she really was. The judge's face changes immediately. What started as sympathy turns to shock. At point 4, most people are dead, he says. That's not just addiction, that's survival against biology. And in that moment, it's clear. This case isn't about one bad night. It's about a deep, dangerous spiral that's finally caught up.
The effect is that they mask each other. And so someone that is drinking while on Adderall, they're drinking, they're not feeling the effects. They're drinking and drinking. Your body is not telling you, okay, hey, we're intoxicated. But all the while, of course, the blood alcohol levels are through the roof, even to a fatal level in some instances. The blood alcohol levels here are, they're up there.
How high are we talking?
High, Your Honor.
Yes, Judge.
Yeah, no, and I understand, and that is
You realize that most people at that level, point 4 is dead.
That's right.
Right? You're at a point 4, you're dead. A normal person at point 3, they'd be passed out 3 times over. Right? It's to be able to get to that level at a point 3 and then a point 2 on that truly tells me that there is an issue there.
Well, absolutely.
Right? And me, with that kind of levels, right? And we have 2 open DWIs.
Now the judge draws a line in stone. He's seen too many defendants promise recovery only to relapse. Every time I deviate, we regret it, he says, the kind of line that defines a courtroom's philosophy. It's tough love, wrapped in legal precision. But here's the haunting part. He's not angry, he's disappointed, and that's worse. When a judge reaches that point, weary from compassion, justice shifts from mercy to structure. Would you call this fairness, or the system's emotional burnout showing through?
If I don't follow the recommendation, because that's why we have these people. They're clinicians, they're experts in what they do. They make the evaluation, they make the choices. I understand it will create a hardship, but sometimes that's what needs to happen to gain perspective and to gain knowledge. You know, I understand your plight. I understand your position. Every time I deviate, you regret. She has a 0.3 and a 0.2. What was it?
2.8.
A 0.28 and a 0.3 on two different DWIs.
That's correct, Your Honor.
I'm sorry.
Well,
Just,
and again, I know that
I
that is
understand.
directly
I'm never going to be
attributed
such a lawyer for, you know, zealously advocating, and I appreciate it. And, you know, you have to do what you have to do. I understand. Sorry. That's just, it's too much. You know, if it was a 0.4 or a point, you know, 1.4, or, but we have a 0.3 and then we have a 0.28. Really, it's too much. I don't know how you want to move forward, but I am sorry. I don't want to deviate from it. You know, we can give you time to make arrangements, but I think that that's the appropriate course of action. I'm sorry, Ms. Treadwell, you know, because there are consequences to actions, right? And I know that it's going to be hard, but I think it's going to be all for the better.
Your Honor, I absolutely agree that, you know, you know, when we're talking about treatment, you know, who could speak against that? And I do understand that.
And we're giving it to you for free. You get out there, you're going to have to pay for it on your own. You're going to end up.
The debate turns financial. Inpatient treatment, the judge argues, is free. Outpatient could cost thousands. It's a rare moment of practicality in a world driven by emotion. The defendant's lawyer pleads that her insurance will help, but the judge shakes his head, only part of it. Beneath the legal back and forth is something deeper, the cost of redemption. Is freedom worth it if you can't afford recovery? And in the cold math of the courtroom, mercy sometimes loses to budget lines.
Thousands and thousands of dollars to pay for it. I can't pay for a treatment on the outside. I'm telling you, I say, I know that you have insurance. Insurance is only going to cover a portion. When you go to these outpatient treatment programs, they're thousands of dollars.
You know, there is also the KEYS program and the Access program that, you know, not really.
No, she's a 0.31 and a 0.28. Really, that needs a lot. That's why they recommended it. And I'm sorry, but you know, I wish I could make a different decision, but sometimes we have to make tough decisions as well, you know? And I'm sorry, Ms. Treadwell, but you know, I will give you as much time as you need to make arrangements, but I truly think that that's the best and appropriate course of action. Okay.
How much time?
I mean, your first case is your second case is 104 days. The first case is 153 days. So you've got some time, but I mean, we're running up against it. You know, I'll give you another 30-day setting, but that's it.
Your Honor, would we give it 45 days? Because there's going to have to be some major movement that is done on her end to even try to get someone and make arrangements for the
I will give
children.
it to you, but that's it. I mean, really,
No, I get it.
at the next setting, it's player trial. I'm not going to play this game. I will give you the 45 days, but everything needs to be done by that time. Okay?
Yeah.
All right. Sorry, sir. Please.
Yes.
Mr. Perez, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine.
Next up, a new face, Mr. Perez. What begins as another DWI turns into something far more serious. A bond revoked, an immigration hold, and a missed court date that changed everything. The judge reminds him, when you come back, good things happen. It's one of those lines that sums up the justice system perfectly. Show up, own up, and maybe the system works for you. But in Perez's case, that maybe turned into months behind bars. One missed date, one wrong step, a lifetime of consequences.
So correct me if I'm wrong, but he was out on bond on this case, right?
Este caso,
Judge, I'm
correcto.
not
Yeah,
not sure
we
about
gave
that.
him a general bond and he failed to appear. You know, Mr. Perez, we gave you a free bond and you got out there. All you had to do was come back. And when you come back, good things happen. I want you to listen. Your failure to appear, we issued a warrant. We revoked the bond. You ended up going back to jail and you spent enough time to where immigration was able to put a detainer on you. That's why you were stuck in there now. For future reference, when you pick up a criminal case, come to court because good things happen. Had you come back, it probably could have been resolved in a good way for you. Do you understand?
Yes.
You also need to understand that what you're doing now is you are pleading guilty to the offense of driving while intoxicated.
We're actually putting on probable cause.
Oh, you are? Oh, I thought you were pleading to.
Judge.
Oh, my fault.
Well,
Well, it may end up good. I don't know.
Actually, once he was detained, he was taken to immigration almost immediately.
Oh, really?
The GOP bond, Judge.
Okay, I thought he got out. You sent to immigration?
Yes, he was denied bond and he was
Got
returned.
it. Okay, well, he got a bond, I guess, because of the GOB, they,
Correct.
so you don't think they're PC?
I don't think there's probable cause in this case, Judge.
Do it up.
Yes, Judge. On December 16th, 2024, at approximately 12 a.m., the officers were stationary on West San Houston Parkway when a prohibited vehicle alert displayed a gray Mustang that was prohibited on the toll road. The officer observed that the vehicle was prohibited since August 25th, 2024, and owed $1,536 to the Harris County Toll Road Authority. The officer initiated a traffic stop. Upon contact with the defendant, who was the driver of the vehicle, the officer observed a strong odor of an alcoholic beverage, red glossy eyes, and slurred speech. The officer observed the vehicle to be registered to the defendant, and the defendant admitted to drinking. Stanfield sobrieties were conducted, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant consented to breath. The results were .067 and .065. And the officer further stated that the defendant's BAC would have been .085 at the time of stop. And that was whatever that, yeah.
Okay. So what's your argument?
So Judge, my concern is that it seems like the police officer has some type of suspicion that he was intoxicated, asked him to do this FST.
No.
Yes,
The
Judge.
stop was initially because it's a prohibited vehicle, right? You owe a crap load of
The next case is all about probable cause. A defendant blows below the legal limit, yet the officer insists he was drunk. The lawyer argues logic, how can you arrest someone for being sober? But here's the legal kicker. Probable cause doesn't need proof beyond doubt. It just needs suspicion strong enough to proceed. The judge knows it's thin, but the law's threshold is low. And that's the brilliance and the flaw of criminal procedure. So what do you think? Should a cop's gut feeling be enough to drag someone to trial?
fines and fees of the toll road. You're not supposed to be on the toll road, right?
Right. But I mean, in regards to the DWI, Judge, I mean, he asked him to do SFSTs, he conducted those, and he doubled down on his suspicion and asked him to do the breathalyzer. An hour and a half later, he blows under the legal limit, 0.065. That's significantly less. Now, it's the cop's suspicion. Now, at that point, he uses speculative reasoning to believe that it was a 0.08 at the time that he was driving without any type of scientific method or any type of legal or actual scientific basis.
Remember, this is probable cause. We can't get into the facts to whether he's guilty or not guilty, whether he's really at a 0.08 at the time of driving. I don't know, but that's why we have trials, to give them the opportunity to respond to what your argument is, because they can't possibly do it now, you know?
Right. I guess my concern is that if you look at the circumstances in totality, I mean, it seems like if the police officer was doubling down on his suspicion, asking to do a breathalyzer, and he passed it, at that point, the other exams were basically just a physical test instead of actually a test for intoxication.
And you may be well right as far as beyond a reasonable doubt. But this is just a probable cause to see if we go forward. Set the case for trial. I think, you know, it would be a great trial.
In that case, Judge, we would ask for the earliest trial.
Yeah, but here we have a good stop,
Yes, Judge.
smell alcohol.
Yes. Then glossy eyes, and then also, I apologize, let me pull up and slurred speech. And then after
They've got
that,
all the indicia to begin the DWI investigation, right? Did they do any SFSTs?
after that, they did SFSTs and they had 6 out of 6 HGNs, 4 out of 8 walking current, 3 out of 4 one-leg stand.
Right. So I think that there's enough just to go forward for probable cause purposes. Now, set it, you may be right as far as they may, it's good for probable cause, but it may not be enough for beyond a reasonable doubt.
Sounds good.
I have to give them at least, we got to give them, 30 days? So we can set up a trial in 30 days. Be ready, watch the videos just to make sure, it coincides and.
Just to understand, I have to wait 30 days to set it, or I
No,
can?
no, no.
No,
Let them know now so that they can get their ducks in a row as far as subpoenas and all that, and is what discovery's in.
Yes, and it's completed, yes, we're just missing station video, but everything else.
Okay, that's a big part, because you're gonna need that as far as breath testing and stuff. So, just stay on top of it. If you want to set it now,
Yes,
you
Judge.
can. If you want us to get it a couple of weeks just to see if you can get the video,
I think
whatever you want to do.
Judge.
Okay, just let Victoria know.
Thanks, Judge. Have a good one.
Hi, good morning, Mr.
I
Lee.
have Mr. Khalifa. He is in custody. And
K, right?
yes, with the K.
How's Mr. Khalifa?
He is,
Then comes a rare courtroom curveball, a case involving Arabic language evidence. The judge realizes the tapes need translating before trial can even begin. Justice delayed by logistics. He sighs, orders a 45-day delay, and it hits you. Sometimes justice isn't blind, it's just stuck in bureaucracy. When evidence speaks another language, the system slows to a crawl. It's a reminder that due process isn't always fast, but at least, in this courtroom, it's fair.
It's just,
he is very adamant. Say that.
yeah,
So
it's an understatement, right?
his felony attorney, I actually know his attorney that's on his felony, and he was here this morning. And I was talking to the chief, and at this point, it would be time to set these for trial.
Okay,
And
it's up to you.
the they're asking for 2 weeks to talk to felony to see if they want to dismiss it. But if it does go to trial, I'll need an Arabic interpreter to review evidence, and I think also.
Are there videos? Hold on a second. Whoa. Have you looked at the discovery?
Yes.
Is there stuff in Arabic?
Yes,
There is stuff in
Okay, so you got to go get all that stuff. Hey, they're saying some of the videos are in Arabic.
For the text.
Right,
The text
but
So-
we need the prosecutor.
Remember, we need at least 45 days to just translate that video into Arabic.
Right, yeah.
So get on it now. Are you going to go to trial on this thing?
If they don't dismiss it, I am.
Okay, so can you send it to you need to transcribe it in Arabic. That takes at least 45 days.
Right, and we just have one ADA who works in our office that speaks Arabic and he has his own document.
No, but they send it out. But you got to put in the order now,
Yes, sir.
if you don't mind, please.
So-
So,
If they don't dismiss it, we have no reason not to go to
yes,
trial.
hey, look, what I'm saying, let's get the order in now
Exactly.
because it takes 45 days. That's why.
Well, they may dismiss, but. I don't know.
And May is a big,
I understand.
I want to make sure that gets done so he doesn't languish in custody because
Exactly.
we can't go to trial until that video is
Well,
transcribed
no bonding on his felony, and that trial date's October 9th.
of next year.
Well, this year now, 2025. Yeah.
They set a trial for October of this year?
And he has no bond in the 179th. So.
I have a trial in October, so go on felony. It got set last month.
Should we just get a trial date out, maybe 2 months?
No. Let's just make sure the stuff gets done. Because when you set stuff out that far, they tend to not look at it because they're just so busy. It's better to just keep little settings so we know that we can get on
Could I
top
do
and
like
stay
a
on top of.
2-week reset and then we'll.
Yeah, you want to eval it too?
Yes, sir.
Yeah, set it 2 weeks, eval it,
Okay.
and then if it's good for you, start putting the video in to get transcribed. Because he says he's going to trial unless you dismiss it, so, yeah, okay? All right, Bertram. Hi,
Need to get more Arabic speaking cases. Sorry.
that would be an interesting case.
Yeah.
Anyways.
All right, Your Honor, I got Mr. Kabir, who's in the boxes for BVR. I have a feeling you're gonna want to
3 bond violations, same defendant, same story. But this time, the judge has had enough. If I let you go, I'm enabling the behavior, he says, and he's right. How many chances equal too many? Addiction meets accountability here like two forces colliding. The defense tries to explain, but you can feel the judge's patience snap. This isn't about THC or excuses, it's about trust. And trust, once broken, rarely gets rebuilt inside a courtroom.
Raise bond or do something, so if
Come on, Mr. Kabir.
if you were leaning towards that, I would like to request a hearing and have a record on it.
Sure.
But that's only if you want to raise. I hope you don't.
I mean, he tested positive. I've asked him not to use. I've asked him not to consume anything illegal. I've asked him not to consume alcohol. He's still using, you know?
Your Honor, it was, I spoke with pretrial, if, just hear me out for a second.
Sure.
Spoke with pretrial, it's presumptively for THC. You know, things like Delta 8, kratom, hemp, those are all legal.
I admonish him over and over. This is our third bond violation. If I let him go, I'm enabling the behavior and I'm saying that it's okay to happen. It's a third bond violation, Mr. Kabir. I'm setting you for a hearing in 3 days. You must be here, be ready to go forward. Do you understand? I can't continue. It's a third bond violation. It's unacceptable.
Understand. And look, I appreciate you giving us a little time for the hearing. I also, and I was here yesterday as well. We are looking like, it looks like we're about ready to set this for trial anyway. Do you want to wait till the hearing?
If you want to set it, you can, but I'm requiring his presence in 3 days here to have the BVR hearing.
You said 3 days or 3
3
weeks?
days. No, 3 days.
3 days.
So that you can get all your ducks in a row, get all the evidence you need. State, get ready, please, as well.
Yes, Judge.
But, you know, if it was a first, we admonish. Second, sometimes, okay, we're now at a third time.
Yep.
No. Yeah, okay, I'll see you in 3 days. If you ever miss again, I will issue a warrant for your arrest. There's absolutely no tolerance in the future. Do you understand?
Yes, sir.
Court orders are court orders and you don't just evade and decide to do what you want to do. Do you understand? You were ordered to go take a test and you failed to go take a test. That's the rub. I'm sending you now for a test.
Sorry, so he has ordered to go get a drug screening test and he did that. They have the results back.
When did you go take the test?
On 16.
Judge, it shows that it came back positive for THC. Confirmed by the lab.
Oh, I see. Okay. No more. No more using. Do you understand? I'm going to test you 50 days from today. If you test again, I'm going to put you in custody.
Yes, sir.
You understand?
Yes, sir.
Okay.
Oh,
All right.
sir.
We got you guys. We'll set you off for 50 days.
So Judge, at present, Mr. Jones has both a scram device on and a GPS, and he's on a curfew. He's broken curfew a few times, Judge. If you look at the times, though, it's because he's leaving a little early and getting home a little late. The latest maybe being half an hour past curfew.
Enter Mr. Jones working hard, supporting family, but missing curfew because of long commutes and picking up grandkids, a real gray area. The judge listens and surprisingly, compromises. He tweaks the hours but holds the line, no more violations. This is what real justice looks like, not robotic punishment, but structured empathy, a system trying to be human without being naive. So, if you were in that seat, would you take the risk and show mercy, or stick to the letter of the law?
Mr. Jones has maintained gainful employment. He's worked as a helper for a transport company. He's not driving, he's the helper. And so he gets on the truck with the driver, he helps, and then they get back to their site. His wife picks him up from work, and then they pick up their grandkids, and then they get home. He's driving from the east side of town, across the ship channel, down 610 West, and then all the way to 90 into Crosby. It's a long commute. And so due to all that, and his employment is working with him right now. So they typically wouldn't be done at the times they're done, but to keep him on, they're trying to make sure he's done by a certain time so he can make curfew, but it's just a tough commute, especially when he's not the one driving and they have to pick up children because there's only one person that can drive. But he is only late and he only leaves early because of work. That is the only.
You have to understand, you have 2 open DWIs, so it's absolute strict compliance. I never want to ding anyone for working, right? I want you to work because I think that, you know, you need to work. Number one, you need to make money and it gives you them something to do so you don't become more self-destructive as it is. I see the violations here. We have no alcohol violations, correct? Okay, that's good.
Joshua or?
Joshua Jones, do we have any alcohol violations?
Got enough problems now, Judge. Trust me.
I don't see any previous violations, Judge.
Okay, so it looks like most of the stuff, I would tend to agree with you that, you know, upon further inspection, it looks like it may be a little bit here, but there, but prior to. Is all this work related?
So
Okay, so what time do you leave for work in the morning?
I normally have to be to work at 7,
Okay,
most times.
because I have here that you leave one time here at 5:56 in the morning. So why that early?
Like I say, most times it's anything that I'm leaving is work related. And one of the things that I've been trying to do since I got out was maybe to get in contact with my lawyer to kind of help me out and
But you're not getting in touch with your lawyer at 5:56 in the morning?
But just because it's a transport company, those jobs have different timelines. They are aware of the circumstances, so they try to tighten up on those timelines. But if they have a job and might need him one day at 6:30 or something like that, that's when he'll have to leave early. And he's afraid he's gonna lose that job if he can't comply with what they're asking of him. So I'm asking today, Judge, if we can loosen the timeline a
I'm
little
okay
bit.
with tweaking the schedule.
Okay,
But I want to do it in a real, I'm not going to give you too much leeway. We have to be reasonable about it, right? So I need a time that you know that's early enough that, you know, you're not going to violate anymore because I don't want to continue to do this, right? So what is a reasonable time in the morning for you to leave?
to if he would have asked me to get to work between 6 and 6:30.
How far is it from home to work?
It's maybe a good hour, 10 minutes if it's bad traffic or weather.
What about coming back home? What's a reasonable time?
It's not.
I'm not going to do 9 o'clock. I'm not going to do 9. I don't want you out that late. I will give you a little bit of time after 7 o'clock, but 9 o'clock is too late. When you're coming home here now, you're coming home at the latest at around 7:30. You know, I'm willing to give you, 7:45, 8 o'clock, but that's the latest I'm going to give you.
8 o'clock is fine.
Okay, so Jillian, we'll tweak it 5 in the morning to 8 at night. If there are any more issues, I'm going to lock you up. I mean, I'm working with you now. There should be no more issues. I want you to work. I just don't want you drinking, and I don't want you out in the middle of the night because nothing good happens out in the middle of the night. And I definitely don't want you driving. Do not drive. I don't care what circumstance comes in your life. Do you understand? I'm really going to hit the roof if you drive. Okay. All right, Jillian.
thank you,
You
Judge.
got it. Good morning, Ms. Claus. So it's come to my attention that you have not signed the waiver.
Then comes a different kind of trap extradition. Miss Claus faces charges not just here, but in Florida. The judge explains her 2 options: fight it for 90 days or waive it in 14. It's the justice system playing chess with time. Even if she's released here, Florida's warrant will still be waiting. You can almost feel the hopelessness. The law doesn't forget, it just waits. It's a haunting moment where the courtroom feels less like a place of answers and more like a web no one escapes.
So there's 2 options that we have here. You can ask for a bond or you can waive extradition. Once you waive, we give the demanding jurisdiction 14 days to come pick you up. In this case, it's Orange County, Florida. That's where you're wanted out of for grand larceny in the 3rd degree.
For what, sir?
Grand larceny in the 3rd degree.
That means grand larceny.
Larceny is it's a theft.
3rd degree, that's,
As far as, I'm just telling you what they wrote on the actual on the complaint, it says I'm sorry, not grand larceny, grand theft in the third degree, $5,000. That's what it says. So if you do not want to waive, that is okay. The waiving, it speeds up the process because we only give them 14 days. If they don't come within the 14 days, Harris County releases you. You got to understand, even if we release you, that warrant from Florida will always remain active until you go back to Florida and take care of it. If you refuse to sign the form, that's okay. We will get a governor's warrant, but that takes 90 days. You're going to sit here 90 days waiting for that governor's warrant to hit. So I will let you make the decision with Chablis, what you would like to do. I don't want you to make a decision here in front of everyone. Take your time.
She does want to waive, and they were gonna give her the credit for Friday when she was originally booked in. They were gonna backdate it to Friday.
Well,
Here's the kicker, though. I just noticed you have an open felony theft case, and you've not made bond on the case. So what happens is that 14 days is typically told until you resolve that case or until you post bond. When all the holds are lifted, at that point, that triggers the 14 days for Florida to come get you. So,
I didn't know you had a case. a
yeah,
local
I mean, I
case.
just noticed it too. So, you can still waive now so that once that hold lifts, it kicks in the
Yes.
14 days. So, well, I'll let you guys talk about it and let me know.
Yes,
Yeah.
thank you.
All right.
Okay, I'll get the
It's close.
paperwork to you to sign. It just doesn't come into effect until you handle the paper.
So Chablis, if she waives, there's no need to bring her back out. We'll just sign it and then I can sign it and then we're done.
Yes, yes.
Working on Mr. Jonathan Joyelle. It's a young man with 2 cases in your court.
Okay, tell me what's going on.
So here's what's going on, Judge. My understanding, and we're trying to confirm from upstairs in felony, is that he's going to WIMAC based on the new violation in your court of a UCW. So that's causing him to be amended up there and go into WIMAC. That being the case, he's currently in custody. He's only going to be released to WIMAC. So at this point, I'm trying to see what kind of options we have for him. I wanted to come to you to see if he doesn't want to plead to this, how quickly can we give him a trial date if he wants to go forward on these cases?
Alex, do we know 100% that they're going to amend and go to WIMAC?
The only note that I have from the prosecutor in felony is saying that the defense told him the defendant is willing to go into WIMAC, but I don't see any clear indication that that's what they're going to do.
The research I've done,
It happened.
the research I've done on the system and on some of the notes on my end, I don't think they could see it, but it says release to WIMAC only. I looked at the activities up there, and based on all the research, it looks like he's going into
Let me
WIMAC.
see, maybe I can see something.
I talked to him as well.
Well, I do see on the same day that note was placed, they dismissed the MAJ and just said that there was a condition amended, so it may be that.
It should reflect in the notes somewhere. I can't imagine that one of the
It left
prosecutors is
explanation
gonna.
blank on the motion to dismiss.
Well, no, not, I get it,
Well-
but don't y'all have like a independent notes to, I mean, every time something happens, you guys should notate what
Yes, Judge, and
happened.
the only note we have that says is defense counsel stated the defendant is willing to go to WIMAC to stay on probation. And then they followed that with a dismissal. So I'm
I
imagining.
see it. No, I see
You
it.
see what I'm talking
I
about?
see it says, so like I have here 131 amended conditions of probation order, release defendant to WIMAC staff only.
That's what I got as well. That's
Okay.
mine.
Kelsey,
yes.
what do you want to do with this case? Because we have these 2 UCWs. While these are open, we can't do.
One UCW, one evading.
Right, I emailed them, Your Honor, and I mean, I need to have confirmation. that
Have you
it's
put an
correct.
offer on this case?
Let me look.
Because maybe you can work something out today. I don't know.
He does, I talked to him. He doesn't want to plead to it.
Oh, well, then if they don't want to plead to it and they're not willing to dismiss both, we'll have to set up a
And
trial.
that's why I'm touching base to see how quickly we could go to trial.
You need at least 30 days.
Okay?
So they're going to need at least 30 days to get subpoenas out. So it'll be a minimum of 30.
Okay.
So I guess the ball's in your court.
He's going to be in here. He's going to be waiting on a bed in WIMAC. My understanding is there's a 2-month wait, so we could hit trial before. Yeah.
Oh, okay, so
So we could hit trial before he goes off to
yeah,
work.
what if,
Like a little time to see if felony can respond and see what's going on and they confirm that.
sure, you want to do like a week to see what they,
Yes, that would be
week or
great.
2? Okay.
Okay.
We'll do a week, because I know that you're itching to get
The
the,
only thing is I lose a week, right? I lose a week. If we're going off to 30 days, I'm losing a week just by agreeing to this.
no,
Okay.
for that day.
All right, let me talk to my client and see what's going on. Okay, thank you. Sure. Thank you.
Do you want to talk about something else real quick?
I had one other one, and here's the,
Okay, great.
Confirm, since she signed the waiver, we're gonna set her bond at 1,500 for silence.
We're setting the bond at 1,500, right? For,
Gonzalez. Cause she came and gave this to me after she signed, but she didn't reapproach with you.
yeah, she didn't say definitively whether. Yeah, of course I wrote it on a docket, and I'm assuming that because she filed that we're gonna set the bond at 1,500.
What is it, a withdrawal?
Yeah.
Yeah, it's a
With it,
waiver.
yes.
Yeah,
If there-
okay. On Patterson,
yes,
540.
Neosha Patterson.
Alicia Patterson, yeah. This was on last,
8810.
it's set for April 3rd.
Yes, I just noticed, I didn't get a chance, you ought to have read the probable cause before I got in here, Judge. But I noticed that, I don't think it meets the probable cause. I was gonna see if we could read it.
Yeah, absolutely. So, oh, you want to do a probable cause hearing?
Yes, we can.
Okay, absolutely. Please.
All right,
Did you get it? The cause number?
yes, what is it, criminal trespass, is that the one we're on?
Yes.
January 24th, 2025, Leo dispatched to apartment regarding family disturbance. Law enforcement officer made contact with complaining witness and former dating relationship with defendant. Stated defendant has been banging on door of her apartment since 1/23/25.
Yeah.
Defendant did not make any threats or say anything besides banging on the front door. Law enforcement officer observed defendant moving around rear seats of complainant's motor vehicle. Complaining witness approached her motor vehicle, claimed ownership, and ID'd defendant as person inside. Complaining witness stated she had recently got a motor vehicle, had not let defendant borrow a motor vehicle or use it in any manner, and also stated that she secured all the seats. Defendant stated motor vehicle was already unlocked, and law enforcement officer did not observe signs of forced entry.
So just for trespass, you gotta either have been warned before, don't come around here, I don't want you here, or you're there and then you're told leave and you don't leave. So this doesn't fit either one of those. I mean, the door's already unlocked in the car. She's never been told not to go in this car, stay there. In fact, this is the lady that the complaint witness was here.
I remember that she was here.
They stayed.
I,
They have a bit of a history together as well. I think there was a prior where the complaining witness.
so the trespass is with regards to the car,
Yes.
okay? Did the complaining witness tell her to leave and she continued to stay? Or was there some kind of notice prior that, hey, you know, I don't want you here, or, I, go through it one more time, will
She
you?
did not let her borrow it or use it in any manner.
She just took the car?
She was just in the car.
She was just in the car?
It was cold that night and she was trying to get in and, I know this isn't here, but the complaint witness told me that she didn't hear the initial call, initial knocks on the door. It was later when she reviewed the Ring camera that she saw her at the door since then, but she heard at the last few, the knocks or whatever. And that's when she viewed the camera and then called the police. But I think it was more of a situation that she wasn't sure about her mental state. I know this isn't here either, but that's what she told me.
Right, but we can't get into the facts that are out because that's not fair to them, right? Well,
She shared with one of the prosecutors, he's not here today. I forget the young man's name. And talked extensively with him.
Oh, with Alex?
Yeah.
He did speak with her. Absolutely.
So did she tell her to get out of the car?
Well, she didn't let her in her house, which
Right, but she's charged with the trespass of the car, right? So did she, at what
no,
point,
but she did go out of her way to say that she has never let her use the car, never borrowed it, let her borrow it in any manner.
so she's just in the car when the cops roll up?
This fact pattern, yes. That's what I understand, having not spoken to the complaining witness myself.
How did she know that she's not supposed to be there? Because from what I understand, they're in a relationship.
Well, prior dating relationship.
How much former?
Not sure of that, Your Honor. There,
Is it something where you broke up 6 months ago and you know you're not supposed to be in the car, you know? Or is it something where it's,
there was a previous charge against the
I mean, let's look at the statute. Hold on.
defendant for stabbing the complaining witness. So
Say it again.
there's a previous charge against the defendant for assaulting the complaining witness. So I would imagine that there's not supposed to be.
Remember, we don't work on hunches, right? It's got to be
Yes, true.
definitive. Texas Penal Code, right now.
It's 30.05, I guess.
A person commits an offense if the person enters or remains on or in property of another, including residential land, agricultural tract, recreational vehicle, park, a building, had noticed that entry was forbidden, or received notice to depart but failed to do so. Did she have noticed that entry was forbidden?
Doesn't appear so, Your Honor. They had been broken up for a couple of weeks at this point. I do.
But Harold, if you're broken up, or should know that you're not supposed to be there, right? I can't just go to someone's car, enter the car. I know it's cold, but that doesn't give me the authority to just go in someone's car and sit in it, right?
Well, it was cold outside.
I don't
She knew it
care.
was her
Even
car.
if it's 100 degrees, you can't just go into someone's car, and just stay there as justification for criminal trespass.
Well, but I mean, we're also justifying the state filing these charges, Judge, by them not having the complete amount of the facts and here the elements. As far as, just like you read, like I said at the beginning too, that no notice entry was forbidden or
Well, no,
receiving
but
notice.
if you're broken up with someone and you're no longer in a relationship, you can't just go into that person's car and assume that you have authority to go there, even if it's 2,000 degrees below Fahrenheit or Kelvin, right? That it just doesn't jive. It doesn't make sense. I don't think that would be a reasonable interpretation. If they were in a relationship, in a current relationship, then I think that would be reasonable. I think that would be okay where you could go into there, but if they're not in a relationship anymore, I think that would be, I don't think that would be reasonable, If you show me something different, then, and I'm all with it, right? But or you should know at that point, you can't just go into someone's car.
I understand, but I did check the report too, and the report mirrors this exactly. So they've got no other evidence, so they might even.
Well, Judge, she hadn't moved out, so she had taken her stuff and moved off the premises.
She had moved on.
She had moved out over a month ago.
Right. So that's what I'm saying. That adds credence to that. You can't just go into someone's car. I know it's cold. There are other places that you can go. And I don't think that that's a reasonable justification.
After 40 minutes of rulings, tears, and legal tightropes, one theme stands tall: accountability. Whether it's a mother battling addiction, a worker fighting curfew, or a defendant facing extradition, the judge delivers the same message. Actions have consequences, and mercy has limits. Every case in this courtroom reminds us that justice isn't about punishment, it's about balance. So if this journey through real-life justice hooked you like it did us, hit that like button, share your thoughts in the comments, and subscribe for more courtroom breakdowns that reveal the drama, humanity, and truth behind every gavel strike.
Yeah, the month.
Violate.
I understand. The month facts are coming from the report. And in that report, she does tell the officers, I saw stuff in there. I live here. My client says that, but we might be able to work this out. I understand.
Right. But nevertheless, they had broken up. She moves her stuff out, and she may be saying that to the cops, right? To be able to not get arrested, right? But what we have here is that they're no longer in a relationship. She's moved on. And yeah, I think that there's enough,
Yeah.
Sorry, Harold.
Thank you.
Okay.